We're going to start our next session, which is legal, and that's probably as important as anything else in setting up a direct primary care practice. And we've got two experts at the individual legal level talking about how the micro in your practice, and then one of our panelists who's going to talk about the macro, about what's going on around the country legislatively, I would imagine, and give everybody the 30,000-foot view. So, what I've been asking, I can't do as good a job introducing you as you can introduce yourself. So please just tell everybody about yourselves, Phil and Jay, and what your area of expertise, what you're representing being up here today. So our first speaker for this session is Phil Eskew, who's got an alphabet soup after his name. I think that you've been in school way too long to get that alphabet soup, but we've all heard good things about Phil and the legal stuff that he does. So without any further ado, let me have Phil Eskew come up and talk with us today.
Okay, so my name is Phil Eskew. I'm a family medicine physician and finished residency in 2015. Prior to all that, I grew up around a family of physicians. My dad's family medicine, my mom's pathology, and I rarely heard them complain about medicine itself so much as the ancillary issues, and I wanted to be able to do something about it. So that's the reason for the alphabet soup. That's the reason I was an accounting and chemistry major. That's the reason I did those things beforehand. And been researching DPC long before I was in medical school. So categories for today, we're going to look at state laws, and we have a Texas focus to it. And after that, we're going to go over the ACA, HIPAA. We'll get into the dispensing and answer some of the questions people were talking about earlier. And then tomorrow, I'm going to save for most of the Medicare discussion. And then at the very end today, we'll do a little bit of some of the common Medicaid questions that happen as well. So, where do we start if we're looking at state law problems? As most folks in the room know, when you start to launch a DPC practice, you get unwanted attention from the insurance commissioner that is fearful you'll charge too low of a price and let too many people join, and you'll make all these promises you can't keep, and that smells like unlawful insurance. In most states across the country, I would say all but the 17 that have laws on the books, this is where you start your analysis, is with the insurance code, and you have to try and dig up that definition. So in Texas, it starts out fairly vague here, and we see this engaged as a principal in the business of insurance. So the next question is, what is the business of insurance? And in Texas, they were pretty specific about it, and specific in an unfortunate way for DPC practices. They actually listed a membership fee and went ahead and talked about direct payment as well. So we had great reason to seek legislation in this state, which fortunately did pass. The other thing you got to consider is, what is your state definition of an HMO plan? And the way that usually tags some DPC practices is a lot of people want to charge on a prepaid basis. This HMO problem is why I always tell people, regardless of what your state law says, just charge in arrears, meaning after the fact. And if you're worried about people signing up and quitting, charge an enrollment fee. That gets around this problem of this prepaid well in advance, and never mind the business of insurance issues you might have, it's also an HMO problem potentially. So under the HMO rules, what is a healthcare plan? It arranges for or pays for, and then we have this prepaid discussion again. I'm moving fairly quickly with these slides. There is kind of a legal reference for the Texas physicians in the audience. And there's a limited healthcare service plans. There's limited versions of HMOs as well. And there's even a single healthcare service plan. All of this is HMO language, and I bolded the prepaid on purpose because that's the important part. You switch that and you're out from under this problem. So what actually happened in Texas? May 28, 2015, they passed House Bill 1945. And what did it say? It said a direct fee means a fee charged by a physician to a patient or a patient's designee for primary medical services provided by or to be provided by the physician to the patient. Simple enough. And they went ahead and actually explained all the subcategories there. So all that's there is a reference for you. We can discuss that in the Q&A if you'd like, but I'm going to keep moving for time concerns. They went ahead and defined direct primary care, and that was a helpful definition. A lot of states failed to do that, unfortunately, and there leads to more confusion between DPC and concierge. I'll let everybody look at that briefly. And then, more importantly, they actually kind of hinted at a different topic under the physician definition. So includes a professional association or professional limited liability company owned entirely by an individual licensed under this subtitle. So CPOM is what I highlighted there. That's for anybody that's sort of thinking bigger beyond themselves. If you're going to hire other physicians and that kind of thing, you need to make sure you're considering corporate practice of medicine. So that's an entirely separate conversation, but it's a problem as you would grow across the state and across the country. Okay, direct primary care, not insurance, arguably the most important provision in the entire act. It says that you're not an insurer or a health maintenance organization. They went ahead and said that for you. So in Texas, if you wanted to go prepaid, because of the way they wrote that, you probably could. I still don't recommend it, but you could. Most states, they didn't specify HMO as well, but that was a nice add-on for Texas. And they went ahead and said that you don't have to worry about the Texas Department of Insurance. Who are you regulated by? The same people you were always regulated by, which is the medical board. Okay, what if you wanted to bill a health insurer or health maintenance organization? They said don't do that. This is very well intended, not my favorite language actually, believe it or not. And so if we read it and analyze it, you'll kind of discover why. Physician may not bill a health insurer or health maintenance organization for a direct primary care that is paid under a medical service agreement. So if you go back in the earlier language of the law, the medical service agreement was their way of referencing the actual DPC contract that you should be signing with each and every patient on their first visit. And the problem with some of this language is this was intended to prohibit double dipping, which is a concierge problem. But where it could be an issue is, what if, I know this is a big what if, and we're all kind of skeptical, but what if Blue Cross suddenly woke up and said, the only thing we're paying for is the monthly fee, we're not going to hassle you at all, you don't have to send us anything. Under this, that's prohibited. So you lost a little bit of flexibility there, and I could see it being a problem sometimes as the ACA RAP plans are developed, depending on how those are structured. Section 162, interference prohibited. So they don't want anybody to discriminate against you based on the notion that you're a DPC physician. And this language was really interesting. Most states don't have this type of detailed discussion. It was born out of real fears that a lot of hospitals don't react kindly to you shining a price transparency light on everything they're doing. So to the extent they can, they make life difficult for you. That's a great idea. If somebody's reading this in a really picky manner, they might try to use this, and I can't tell you this would work, but it's a neat argument. If you had a non-compete with a hospital and you're trying to quit that contract and you want out of it and you're worried they're going to enforce it, this might help you argue against them. They usually say, hey, I'm switching solely to DPC, and if you read this to the letter, that could help you. Okay. Required disclosures. These are always helpful in the event these things are challenged in front of a judge and somebody tries to invalidate the entire law. If you have disclosures, these are viewed as extra patient protections and they increase the chance it's going to withhold judicial scrutiny. So this was well written and very helpful. Basically, you need to disclose to the patient that you're not insurance, which we're already very adept at doing. So, state DPC law comparisons. If you're looking at Texas and comparing it with other states, what are the things you want to pay the most attention to? Does it have a not insurance protection? Arguably the most important reason for the law. Believe it or not, some of the 17 failed to include that very basic concept. Does it have a clean definition of direct primary care and prohibit double dipping without causing ancillary problems like what we see here in Texas? Do they have mandatory not insurance disclosures? Just went over that. Written agreement requirements. The more detail they give you to put in the agreement, the easier it becomes for you to write a lawful agreement, and the less you need to spend on local legal counsel because they've spelled it all out. So the better states tend to give you more of a guidebook than the ones that were vaguer. Policing authority should remain with the medical board. There are a few states that passed DPC law, most importantly Washington State, which was one of the earlier ones, that basically said if you do X, Y, and Z, you're not insurance, but oh, by the way, the insurance commissioner is still going to require data and you have to report all these things to him every year, and he has the ability to audit your practice. So sort of a strange dichotomy there. Data reporting obligations, we just mentioned Washington does that, Oregon does that, there's several states that do that, and there's a few others like West Virginia that had a separate licensure process just for this, and it was part of a pilot program, and you had to be approved by the same entity that does their certificate of need. So all those things you want to avoid. Fortunately, they happened with the earlier laws rather than the later ones. So here's a sort of snapshot of what it looks like across the country. There's 17 states that are highlighted there. If they're green, they helped you. If they're yellow, they didn't do anything worth even talking about. And the red ones had law that was really more unhelpful than helpful. I would say, some people say, do I want to propose legislation? What if I become a red state rather than a green state? I think that's not as much of a hurdle as you might expect. If I were doing DPC in West Virginia, I simply wouldn't pay attention to the pilot program. I'd take the same precautions I take in any state that doesn't have law on the books, and then if you have a legal fight, you have a legal fight, but you know you're going to win it. Jay's going to talk to you more about, if you notice there's no states in blue, unfortunately, which means nobody, at least to my knowledge, has an active a House bill or Senate bill right now that's being considered. We're not really in session in most states, but there have been conversations in lots of these other ones, Kentucky, Virginia, Pennsylvania. Florida's had several bills that Lee's been championing, so we'll probably see more legislation in the coming years. Affordable Care Act, what does it say about DPC? I've seen several DPC websites that get this wrong, so please do not misadvise your patients here. The Affordable Care Act does mention a qualified direct primary care medical home, and it goes so far as to reference Washington, that's Washington State, not DC, as their definition for what DPC is, which fortunately is a pretty good one for us, and it has a nice broad scope focus on what qualifies as primary care. Where people mess this up is that the Affordable Care Act allows you to have DPC paired alongside a WRAP plan in the health exchange. And when you buy those two products together, you have met the requirements to not be taxed, as John Roberts would say. So buying DPC by itself does not get you out from under being taxed. I've seen a few websites that say that, and that's a bad thing because it's wrong. Buying a health sharing ministry by itself does get you out from under being taxed. That's an exception. DPC alone is not an exception. What DPC does is it lets you buy that mythical catastrophic plan we were talking about earlier that really isn't offered anywhere. And suddenly that catastrophic plan that specifically carved out primary care is now legal because it's bundled with direct primary care. That's what it lets you do. Okay, there's an error on this slide. Anybody see it? I like to quiz people on this, so I threw it in there on purpose. Yeah, there's 2 A's in HIPAA, right? It's not hippopotamus. But I see this in contracts all the time. It drives me crazy. It lets people think that you didn't necessarily do your homework. So it's always 2 A's. The future slides will have it that way. Covered entity is one of those buzzwords in HIPAA. Business associate. We'll go over each of these here, and then we'll discuss how they interact with each other. So to become a covered entity is what most physicians' offices wind up structuring themselves as. If you electronically transmit health information in connection with one or more standard transactions, so treatment, payment, or operations are your typical standard transactions, then you are covered under HIPAA and you have to follow all those rules. Plenty of practices out there that are outside of the system, be it DPC or cash pay fee for service or otherwise, like to brag that HIPAA does not apply to them. If they're very careful, they might have a strong legal argument for that. I don't recommend bragging about it publicly, because there's a good chance the government could find a way to make it apply. But to the extent you can avoid this electronic billing because you're a pure DPC practice and all your transactions are one-on-one with the patient, then you can start to structure that argument so that if you do have some sort of HIPAA claim filed against you, your first argument against the government would be, hey, I'm not a covered entity. Business associates are the people that you work with, whether it be an attorney, accountant, whoever that you're sharing some information with. Technically, every pharmacy you send an electronic prescription to is a business associate, and you were supposed to have a BAA with them. But I don't know anybody who's doing that. So this is sort of enforced in haphazard ways. But the biggest people to worry about from a business associate standpoint aren't really your other pharmacies or other physicians, because those are generally covered entities as well. It's the people who otherwise wouldn't be, like the accountants. So protected health information, PHI, as it's commonly abbreviated, that's anything that could identify the patient as sort of leading back to you. If I have a practice in New York City and I use the initials ES when I'm doing a comparison and say this is ES, he was born in 1985, then that's far less likely to be identifying to him than if I'm in Lusk, Wyoming, where there's 1,000 people. Right? You might be able to figure out who that is. So if you shared information that could be traced back to the patient, that's potentially PHI. Treatment, payment, and operations. Those are the big three areas by which you share information under HIPAA. So it's two A's for a reason and one P. So Health Information Portability and Accountability Act, right? So the P is portability, not privacy. So this is how you share under HIPAA. If the patient wants their information to be especially protected, they should not sign the HIPAA form that the hospital shoves in their face. Because if you don't sign it, then the hospital is supposed to come to you every time they share information. Whereas if you do sign it, you're giving them permission to share it for TP&O. So DPC approach, as I sort of spilled the beans here, it's more of a risk mitigation focus. Your first defense, if you structure it right, is that maybe you're not a covered entity. The other reasons you want to apply is that there's a good chance you lose that argument, number one. And number two, most states have other law on the books regarding patient privacy. So, and that often mirrors the federal law under HIPAA. So if you're complying with HIPAA, it's sort of, there's a good chance you're complying with everything else as well, even if you didn't necessarily read that code. You want to do a risk assessment, which you want to update on an annual basis, which basically tells the government, hey, I take privacy seriously, and here's how. I have these passwords. I have, X, Y, and Z, things that you do from a compliance standpoint. Provide evidence of that to meet the privacy and security rules. There's certain standard forms that you have out there. AAFP has example forms. I've got them linked on DPC Frontier. You don't really need to invent these things. The Notice of Privacy Practices, Business Associate Agreement, and that kind of thing. And then the last thing that you sort of owe to the patient if they ask for it is what's called an accounting of disclosures, which means maybe the patient's been in your office for 3 years and they say, hey, how many people did you actually share my information with? And if you say, I don't know, I sent it all over the place, that's not a good answer. You need to be able to say, yeah, I sent it to these 5 groups and here was why. And that's your accounting of disclosures. Patients' rights, okay, sort of mentioned some of these. Notice of privacy practices, so that's what they sign up front if they choose to sign it. That tells them how you're sharing their information, more so than how you're protecting it. Accounting of disclosures we discussed. They can receive a copy of their own protected health information. They can request corrections be made. So if you're sending them the full SOAP note, no, you don't have to change the subjective, but if they said, they have an allergy that you've missed, then you should be correcting that kind of thing. And request limits on how it's used and disclosed. All that's kind of intuitive. Okay. This part we'll come back to later if we need to. I think we're a little behind. Tax laws. Jay will get into some of this. I can save some of this for Q&A. This is always a mess. The IRS made it. I didn't make this mess. Don't blame me. So the first question that patients typically ask is our second bullet there. It's a 213D question. Can I pay for this with my HSA? Is this a qualified medical expense? If you and I read the tax code, which we could, it'd be no fun, but we can, we would immediately conclude that DPC is a qualified medical expense because all logic tells you that it is. The IRS, typically, they don't have folks with medical degrees. They don't try to expand any tax write-offs that they don't have to. So they interpret this as not a qualified medical expense because they see the periodic fee. So that's the first problem. The second problem is that they view this as a gap plan. In order to have an HSA, you have to have a high deductible plan. I think it's $2,700 or something like that off the top of my head. And if you have something that covers healthcare costs under that deductible, then they say, wait a minute, you don't really have a true high deductible plan. Either you have a second plan or some sort of weird hybrid we don't understand. So what do they do when they see DPC? They view it as a gap plan that pushes you under whatever that cap was to meet the requirements to even contribute to an HSA. So you have two problems. One, they think it's illegal for you to continue contributing to it and to use the money for anything, should you have DPC. And two, they think that it's not a qualified expense for you to pay for DPC. The third issue is the bottom bullet there. a $100 per day excise tax under 4980D. So if you're a large employer or even a small employer, even if you're one of the guys who's in the less than 50 category, if you offer a plan, under the IRS vague definition of plan, that doesn't meet the requirements of the ACA to your employees, and you didn't offer them the full ACA plan, even if you weren't forced to do this, meaning less than 50, if you offer a plan that's less than the full thing, we're going to charge you a potentially $100 per day excise tax, which has a lot of the small businesses spooked. What's the solution to all this? Jay's going to tell you about a bill we're pushing to fix a lot of the HSA problems, and there's a separate one that NFIB, National Federation of Independent Businesses, has been pushing that I think Lee Gross probably knows a lot about because he's worked with them a lot to fix the bottom problem. What I would tell you for now is just stay quiet about this for the most part. I've seen several websites that sort of promise you can do this, that, or the other. This is not your legal risk. Unlike everything else we've talked about before this, whether it be HIPAA, whether it be business of insurance, that's your call, because that's your risk to take. This is not your legal claim. This is your patient's legal claim, or the employer you worked with's legal claim. So they need to talk to their attorneys, they need to talk to their accountants and come to a conclusion on this. I will say that in a weird way, if we win the argument for 223C, we could lose the argument for 213D and vice versa. I can get into that more at the Q&A if you want to, but it's messy. In-office dispensing. So most states, I might bump forward here, most states it's fine. If you're green, you're good to go. If you're red, you have to think twice about it. If you're yellow, you got to probably register with a few groups and you can still do it. It's just a pain. So since we're in Texas, let's talk about Texas. This is the problem. 158.001, physician licensed under the subtitle may supply a patient with any drug, remedy, or clinical supply necessary to, quote, meet the patient's immediate needs. And then they say this is not permission to permit a patient to operate a retail pharmacy without complying with Chapter 558. So how does this come down? In Texas, if you want to supply more than 3 days of medication, they want you to meet Chapter 558 and basically be a pharmacy, which for most physicians means it's not worth the headache. Pathology for direct billing. So if you're working with a group like Cold Diagnostics and they're charging you $40 or $50 a specimen, something like that, the reason that price is so low in part is because they're charging you. And you've arranged that relationship with them. They don't have to go through any hassle of collecting money from the patient. The same thing is often true with radiology and, as you know, lab pricing. The irony is we have something called pathology direct billing laws, which were passed several years ago out of fears, mainly in the dermatology sector, that the dermatologist would do the biopsy and the pathologist might charge the practice $100, and then the dermatologist would turn around and charge the patient $200, and this relationship between the two might not be disclosed. So rather than requiring disclosure, which would have been the states in orange, which makes some sense, several of the states that got red said we're just going to ban this whole thing. The only way to have this go on is to have that lab directly bill the patient themselves, which typically means you're not going to get these same low prices, because now there's an administrative overhead hassle factor. So this is not your blood draws. This is typically for family medicine, your skin biopsies, and anything else you might send to a pathologist. So take note of that depending on where you're at. I will step back one more time. When it comes to labs, the only two states I'm aware of where this is a problem just for basic labs are New York and New Jersey. Medicaid issues. When it comes to Medicare, which I'll talk more about tomorrow, if you want to privately contract for covered services, the only way to do that is to opt out. If you don't want to opt out, the only way to sort of see people on a periodic fee basis is to do a non-covered services agreement, which is common in concierge and a bad idea in DPC for reasons I can elaborate on later if you like. In Medicaid, it's different. There is no opt-out of Medicaid because you aren't automatically in Medicaid unless you tell them you want to be in Medicaid. If you stay outside of Medicaid, never sign up, and they don't know you, then you're perfectly free to contract privately with your patients. You never had to get anybody's permission to do that. Because of changes in the Affordable Care Act, it's now become more of a hassle because when you order a prescription that you didn't dispense to the patient in the office and they go to Walmart or wherever to get it filled, Medicaid won't recognize that you exist, and they won't fill the prescription. That's often the case for radiology orders, lab orders. If it hasn't happened to you yet, you're lucky, but you should expect it. What can you do? Under the ACA, there's also a category for referring and ordering only provider. And Texas is a good example state because they actually have all this listed. I think the next slide has it cited there. You can go to that website and see the full document. And when you sign up for this status, they know that all you're going to do is order and refer, that you're not going to be billing Medicaid, and they're perfectly fine with you going ahead and privately contracting, even though you're sort of known to and in a sense signed up with Medicaid. So that should be possible in every state, but the majority of them don't have this language, don't have this form, and so it's a little bit of a hassle. The only place that I'm aware of that it's illegal to privately contract with Medicaid patients is Kentucky. That's because of a bad law that was signed by the former governor that we're working to reverse based out of fear of abuse for what I think was abuse and cash transactions for any type of controlled substance that sort of had all this collateral damage in the DPC world. So if you have questions, that's my email. We'll have a Q&A after this, and Jay Keese will come talk to you. He's our, he heads a lot of this stuff at the federal level. He's with the Direct Primary Care Coalition. He and I do a lot of work together. He's been very valuable to this movement. Everybody in this room has benefited from him, whether they know it or not.
So just by way of background, I got a lot of questions as we'll get the slides up about how I got here. Hands, how many people know Garrison Bliss from Q Alliance? Sort of one of the godfathers, I guess, of direct primary care. Garrison Bliss came to me when the Affordable Care Act was being discussed on Capitol Hill and said, this thing is terrible. It's going to require that insurance cover primary care and that everybody have insurance. What am I going to do? I work directly with my patients or directly with businesses. What can we do to repeal this, or what can we do to stop this? And I said, there's absolutely nothing you can do to stop this at this point. The best thing that you can do is join and try to fit within it. So what we were able to do was essentially to put the provision that Phil referenced in the Affordable Care Act that says, if you have a direct primary care medical home, and we sort of invented the term of art, direct primary care medical home, because the idea of a medical home was a very popular bipartisan term. So fitting within the confines of the act, there was already a definition of what a medical home did, which is essentially what you all do, which is primary care. So we took that and said, okay, working within the confines of the way the Affordable Care Act works, we're going to sort of split the baby. We're going to say that there's two entities that can provide your health care for you under the Affordable Care Act, whether it's being provided through the exchanges or through a business that would provide covered insurance under the essential health benefits, that you can meet those essential health benefits requirements by contracting with the direct primary care medical home that works in conjunction with a qualified health plan. So those AB-rated preventive services and all those other things that are required primary care coverages could be covered by the DPC medical home. And then, again, as Phil referred to, this sort of mythical wraparound insurance plan would cover the rest. Now, this is being done in a few places, and we'll get to that in a minute. But essentially, to sell this, we had to convince the entire Congress. We had to convince members on both coasts, from both parties, from both houses of Congress. So what we did is we created essentially a coalition. I think at some point, some of you in this room might remember, Garrison sent a note around to people that he thought were doing this very practice and said, would you sign up and become a member of this Direct Primary Care Coalition? Well, long story short, the Direct Primary Care Coalition, which can be found at dpcare.org, has survived this because, obviously this wasn't the last legislative or legal hurdle we face, and there's a lot of work to be done to make sure that laws in this country, both on the federal level and the state level, are put in place that actually help this movement grow and help you do what you're doing so well for your patients. I'm not going to spend a lot of time on this. I think everybody in this room understands what direct primary care is. That's why you're here. This map gives you an idea of how it's spreading, and this was a much smaller map even a year ago or 2 years ago, let alone in 2010 when the Affordable Care Act was promulgated. There are now DPC practices in over 47 states in the district. The median fee is about $70 per month, and we'll show some data, which we show to policymakers all the time, that says there's savings of up to 20% off the total cost of care. DPC is being done with private insurers, with health plans, even in hospital systems now, in the exchanges and in Medicaid. It's virtually happening in almost every part of the healthcare ecosystem. Again, it is defined in these state laws as being, refers back to the Washington law and all these 16 or 17 various state laws that essentially define direct primary care as a medical service that is outside the scope of insurance regulation. So it does differ with concierge a little bit, and it's not to say that there's anything wrong with concierge, particularly for people with higher incomes. It does get you better care. It gets you better access to the doctor. The differentiator here is that in DPC, the entire fee is the fee that's paid in the agreement between the doctor and the patient. And as far as the coalition is concerned, we really don't care who pays that fee. I mean, if Medicare wants to pay it, if Medicaid wants to pay it, if a private payer or an employer wants to pay it, the key is that relationship, or essentially that contract, is between the doctor and the patient. And so you think of it as the insurer or the payer essentially buying a relationship with a DPC doctor for that patient and working on that patient's behalf. I think it's cleaner, regardless of whether or not the agreement is with an employer or an insurer, that there is a contract between the doctor and the patient that outlines exactly what you're going to provide for that patient, and also, what the patient's responsibilities in the relationship are. It does create this sort of two-way street, which really presents a nice opening in a lot of these state laws for you to be able to define exactly what it is you're practicing. Your practice is defined by what's in your agreement under most of these state laws. And the assumption is under the federal law, that's the same thing because it does, as Phil mentioned, refer back to the Washington state law. Also, importantly, the federal statute says that what you're doing is not the business of health insurance, even though they don't really have a lot of jurisdiction over that. The Department of HHS says that. Obviously, we have some problems with the IRS with that, and we'll get into those in a minute. So here's a little bit of this data. Now, this is 2013 data that comes from Q-Liance. I'm sure others in this room have similar data. One of the things the coalition is trying to do is to sort of aggregate and put this together. So anybody, we obviously encourage you to join the coalition, but anybody who wants to share outcomes data that looks like this, that says, specialist visits are down, hospital inpatient days are down, radiology is down, but primary care visits go up. And businesses that are in these relationships are saving up to 20% of the total cost of care. Iora Health, that was mentioned in one of the previous talks, how do you do this in the context of Medicare Advantage? How do you do this in the context of working directly with one of those MA plans? Iora is doing that, and they're showing data of reductions of at least 12%. Again, this is in an employer population. This is with the, I believe this is the culinary workers in Las Vegas. So there's a lot of data out there that says that this model is not only working directly with the patient, but it's working in the system too. And one of the things we're trying to do is make people understand that this isn't just doctors completely opting out of the system. It's doctors working within, maybe, creating a little lemonade out of the lemons that they got in the system and really trying to work around it. So we do have examples of where things are working in the exchanges. Harken Health, some of you might have heard about, is offering plans in the exchanges in Atlanta and the Chicago area. And that's a joint venture between United Healthcare, which recently said they're getting out of the exchanges, and Iora. So they aren't getting out of the exchanges. They're doing direct primary care in the exchanges using the provisions that we put in the Act. And these are just some examples of some of the relationships that are out there. We have health systems, small businesses, large businesses, unions, integrated health systems that are starting to take a look at working with direct primary care, realizing that that relationship between the doctor and the patient brings real clinical value and helps reduce costs and get better outcomes. I think one of the most exciting programs that's going on is happening in New Jersey right now, and we have at least 2 direct primary care outfits in New Jersey, Our Health and I believe Paladina, are going to begin to work with a New Jersey State Employees Fund. This was a program that was initiated by the 9 state public employees unions in the state of New Jersey who said, you know, we want to have access to this better kind of care. Yeah, we want concierge care, but we want it for union members. We don't want it to be the CEO executive plan. We want everybody to have this level of access to care. So essentially it's a voluntary program that puts place, and admittedly we can show you, and I think we have on the website, the request for information that was put forth by one of the payers, Horizon Blue Cross. There's a lot of hurdles to jump through, and a lot of people would probably choose not to do this. It doesn't exactly look like primary care, direct primary care looks like everywhere else, but it's a good start, and the potential for growth is huge because it will be offered to up to 800,000 employees in the state of New Jersey. So watch for New Jersey to scale and grow in DPC and watch how this goes. I think the payers have a lot of flexibility to reduce some of the hurdles that have been put forth. And as they get into this practice, we're sure looking forward to working with the union payers, with the TPAs, Aetna and Horizon on this program, and obviously the DPC practices that are working on it. So let's get into some of the policy issues. We'll talk about some state legislation. We'll talk about the problems in the health code. I think Phil outlined those brilliantly. I mean, the problem is that the IRS does not agree with the HHS and does see you as a health plan. So we have some legislation that's out there to fix it. And another priority that we have is, you know, as we move into, some of you might have known if you're still doing fee-for-service, that the macro rules came out today. So instead of SGR, now you're going to have MIPS and APMs and a whole new set of alphabet soup. And CMS gave you some flexibility in terms of how you're going to have to comply with that. But one of the things that's crystal clear is that there is a window of opportunity to do direct primary care as a medical home, as an advanced payment model in the out years, should the Secretary take a look at some of these programs and things that are happening in Medicare Advantage, like we're doing with IORA and in Medicaid with, out in Seattle with Q-Liance. There's a pathway to be able to do this, and we're working hard to make sure that CMS understands exactly what that is. On the state level, as Phil mentioned, these are the states that have passed legislation. He always dings me because I leave out Arkansas, and it doesn't even mention direct primary care. So we sort of consider that one, you know, maybe a non-entity. We do know that there are going to be additional states that go after it. At my count, I think right now it's about 8. We've heard from folks in Colorado. Lee, I think Florida is probably going to go at it again and try to do that. Florida and Georgia both had bills last year that did not advance, you know, out of committee. Kentucky, Massachusetts, which we'll talk about in a minute. Michigan is going back at it to try to do, Senator Colbeck that was talked about before, wants to do a DPC Medicaid pilot, and we've been working directly with him on what that would look like. We just heard about Pennsylvania the other day. The Academy of Family Physicians in Pennsylvania is working with Phil and our group to try to work on a bill for Pennsylvania where DPC is growing and thriving with a couple of large network-style practices. And sadly, we will be back again in Virginia, where Maura McLaughlin and I worked hard together last year to try to get a bill passed. We did get that bill passed 97-0 out of the House and by a slightly smaller margin in the Senate, promptly to be vetoed by the governor, Terry McAuliffe. So we'll be back at it again. We did have some difficulty with the insurance lobby in the state of Virginia that I think really didn't 100% understand what was in this bill. They argued that it should have been in the medical titles instead of in the insurance code. And they lobbied very successfully one of their highest donors, the governor of Virginia, to veto the bill at the end of the day. So it was caught up in a political battle, and one of the things that happens in some of these states is that conservative legislators get up and say, this is the answer to Obamacare. This is going to replace Obamacare. It's going to be better than Obamacare. It's cleaner. It's a more direct relationship. And while you might believe that, that causes a lot of political consternation. There are some people that don't like that don't want that to happen, and a lot of these laws do get caught up in that. What we try to do is come in, and we testified in West Virginia a couple of weeks ago, and in West Virginia we're trying to fix that law. It is one of the bad laws, and repeal the very limited, narrow pilot, and expand it to the entire state. What we're saying, and it's the same thing we're saying on the federal piece, is that this is a simple clarification of insurance law. We're not trying to repeal and replace Obamacare here. What we're trying to do is define in the state's law that what you all are doing is not insurance, that you can do it, and to set forth some things that probably ought to be in your contracts that protect consumers a little bit. And those, for the most part, those are the attributes that are in some of these good laws. And we're working hard to try to get some of that accomplished. We're also working on a regulatory level. This is a letter that was sent to Jeff Gold, who is in the audience, from what was earlier arguably the most hostile insurance regulator in the state, that essentially came to IORA and said, you can do your direct primary care practice in any other state but ours, because what you're doing is the business of insurance. Created a very, I think, rich guidance to Dr. Gold about what he can and can't do in his practice in terms of meeting the code's requirements. We're working very hard. There may be a legislative effort to get this codified. Right now it's a guidance, but as far as I'm concerned, and Phil, correct me if I'm wrong, I mean, any other physician can look at this guidance and say, if I'm practicing like this, that I'm telling my patients it's not a health plan and it doesn't satisfy minimum coverage requirements under the ACA, and that services are not covered by insurance, and that these services are specifically identified, and here's what they are. If all those things are in your contract between your doctor and your patient, you're good to go and you're not insurance. So that's a really valuable piece that came around last year that really clarifies the law in Massachusetts. So we can do some things on a regulatory basis, which is what we've tried to do with the IRS, but it didn't work. We went into the IRS and we said, well, look, and actually, not only did we go in, we took a group of the Coalition Steering Committee members in, including Rashika Fernandopoulos, who's doing this in combination with insurers. And we were actually introduced to the IRS by the senior tax health policy official from the White House. And he came in saying, look, the Department of the Treasury would like the IRS to take a look at this and figure out if there's a way that we can do this. It's in the Affordable Care Act. We think it ought to be. And the IRS stood up and said exactly what Phil said, that what you have here is essentially a gap plan that comes between the high deductible health plan and the HSA. And the law does very specifically say if you have an HSA, it has to be paired with a high deductible health plan, and there shall not be a second health plan. So as long as the IRS looks at this, and they looked right at us and said, well, go pass a law. So that's where we are. The Primary Care Enhancement Act, we've just had the House version introduced in the bill. Earlier in the session, S. 1989 was introduced by Senator Bill Cassidy, who's a doc from Louisiana, and Maria Cantwell, a Democrat who's on the Finance Committee. In the House, it was introduced by Eric Paulson, a Republican from Minnesota, and Earl Blumenauer from Oregon, who's a Democrat on the Ways and Means Committee. And it very simply says that DPC is not a health plan under 223C, and that DPC care is a qualified health expense, even if it is in a periodic fee under 213D. And it would allow, if passed, it would allow for DPC to be paid with by an HSA. I think you all have this sheet, which is a little set of talking points about HR 6015. We're in a very narrow window between now and the end of what will be the lame duck session of Congress after the election. What I'd like each and every one of you to do, and there's some help with this on the dpcare.org website, is send an email, call your member of Congress and ask them to co-sponsor HR 6015, and ask them to include it in this year's budget package, because that's what we're trying to do. It will not go as a standalone bill at this point in this Congress. If we don't get it done by the end of the year, which, frankly, at this point I think is more likely than not, we'll be back to fight this again in the 115th Congress, and we'll be asking you once again. both your senators to sponsor S 1989 and HR 6015. So there's a little bit of difference between the two bills. The tax language is precisely the same. There is a Medicare pilot in the Senate version of the bill. That Medicare pilot, I know there's probably a lot of people in this room. I think Hal and I have had some conversations, and Lee and I have had some conversations. And people would say, well, we don't really want to take Medicare, so we're not going to do that. And that's exactly what this law says. It creates a pilot, and if you don't want to do a Medicare direct primary care pilot, you wouldn't have to do it. But essentially what it does is it creates an ACO-like structure in which Medicare would pay you that fee from fee-for-service Medicare, and it clarifies that you can do this in Medicare Advantage, and it does some things to fix the opt-out problems. Those are all likely to fall out of the bill. This is really going to be a very narrow tax provision as it's written in HR 6015. They're both called the Primary Care Enhancement Act. We really do want your support on this, and I think it's the most important thing you can do on the federal level this year is to contact your members and ask them to support this legislation. It's really important, and if I leave here with one thing today, I'd love to see some calls and some emails into folks. And I'll be around the room if you have any questions later today about exactly how to do this. And again, right on the front page of the dpcare.org website, there's a lot of resources and information, and you can actually download another copy of this sheet if you need it.
Jay, thank you. That was great. And Phil, thank you. I have one question that I'd like to take moderator prerogative. So from a state standpoint, you showed 17 states where there's DPC legislation. Is there a way that people can get involved, get engaged, use model legislation so that they can go to their legislators and try to advocate for this?
Yeah, we have model legislation on the Direct Primary Care Coalition website. Phil is the author of said model legislation. It has been the model in, I would say, probably about a dozen states. So it's very clean, it's very simple, it's out there. We just encourage all of you to join the coalition, get involved. We do a couple of fly-ins a year. We are actually going to do a fly-in in a state capital this year. It's likely to be Virginia because we got a big fight there. So yes, get involved. Contact me. I can be reached anytime. I'm very transparent. All the contact information is on the website. Really happy to have anybody not only in the movement but interested in being in the movement be a part of it. And when these bills come up, there's opportunities to testify, particularly at the state level. You know, you saw the 8 states that are going at it. My guess is that some of them will, some of them won't, and there'll probably be a couple more that we're missing that aren't going to be in there. So somewhere 6, 8, 9, 10 states might be doing this next year, and they all need to hear from you. Your state representatives, your members of Congress, everybody on these issues.
Yeah, to the extent I can, even the proposed legislation, I try to link on DPC Frontier. I mean, I've got everything has a state page to it, and if the state has passed legislation, there's always a link to that legislation that was passed, so you can just, go straight to the language and not have to search for it. So that should make it easier too.
That's great. And Docs for Patient Care Foundation is happy to help in this, so you can also get in touch with us, and we'll do whatever we can to bring people together so that we can have a more powerful voice at the state capitals. Let's go with a couple of questions, and then we're going to break.
Sure. I'm Jeff Gold, who Jay was nice enough to mention in the lecture there, but I get greedy, so now I'm sitting here thinking the whole time about another legal issue where Massachusetts is a state that we're not allowed to dispense. I always find it funny because CVS Minute Clinics can have a pharmacy and a clinic right in the same spot, but we can't. And maybe Phil is better off answering this, but how do we pick up that fight now? And because I think that I just got a text from one of the brokers we work with that Massachusetts has just eliminated pretty much all PPO plans from the exchange and on the individual and family market. Which I think is also going to impact us a great deal because of the referral issue. So if we could somehow get that added benefit for patients of being able to do wholesale dispensing, right? How do we take that on?
So The best theory I have for why these laws were passed in the first place was out of historic abuses in the workers' comp sector, where the practices that tended to dispense were taking workers' comp, and they were charging a ton of money for meds, like far more than the pharmacy was. So when you have these political conversations, it becomes another educational piece where you have to go in and say, look, these are what my prices would be. I'm showing you the wholesale rates at which I get it. I'm not marking it up. This is the way it is. Why in the world do you want to block this? If I'm smart enough to write the med, I should be smart enough to hand them the med. Especially for the top 20 or 30 you write, you don't need to run those by a pharmacist. You can look up the interactions yourself. So it's another educational battle. They've tried to have it in Texas. There's probably a lot of folks in this room who I think were on an email chain with myself and Josh. They've pushed against it 2 or 3 times, and it's not worked, unfortunately, but maybe we'll have better luck in Massachusetts.
And I would just say it's really important that you pick your battles carefully and prioritize what's the most important thing to have happen. And frankly, I would say, particularly when it comes to issues like dispensing or any kind of scope of practice issues, keep them separate if you're trying to pass a DPC law that codifies you as not being insurance. And I think from a strategic standpoint, you're more likely to have better traction once you get the law passed that says you can do what you do to work on something like dispensing. And you might have additional allies outside of DPC that'll help you fight that fight.
There, over there.
Okay, I'm Melissa Phillips-Black. I have a 12-month-old DPC in Atlanta, Georgia. I am primarily geriatrics and 80% Medicare. My question is specifically about the ACA wording that says you can use a DPC medical home with a wraparound health plan and have that satisfy the requirement. When the legislation uses the words medical home, is that a loose term to mean your place of primary care, or is that a formal term meaning what I do has to meet the NCWA patient-centered medical home requirements?
No, it doesn't require you to comply with the commission standards. But what it does do is look back to the provisions that define a medical home within the Affordable Care Act, which are actually pretty good, and just pretty much say that these are the things you need to do to do primary care.
Over there.
Hi, I'm Eva Mackey-Mayraw, and I'm a family physician. I work currently for Baylor, Scott & White, and Mesquite, and pretty soon I'm going to leave and open my own DPC clinic. And so I had questions about in-office dispensing in Texas also. So I know that it's not easy to do, but I heard one DPC doctor who works in Dallas say that you could do it if you don't make a profit, and then I thought I heard somebody say that you could do it if you had a pharmacy tech license or something like that. So is that true? Just, can I get you all to clarify that?
This is a mess. I'm a member of the...
He's a lawyer now, not a doctor.
I'm a member of the Kentucky Bar and also South Carolina, not Texas. Don't want to be in Texas. I can't keep all these licenses up. My interpretation of what I've seen and what I've read about the law from other people commenting on it is that unless you're in a very rural area, I forget how that was defined, 10, 20, 30 miles, whatever it was from a pharmacy, you're really not going to dispense more than 3 days' supply of medication. I've not read or seen anything commenting about not marking it up, because that looks more like a disclosure law, which is what we see with the pathology direct billing laws, and I've not seen any evidence of that in my research of the Texas Code. So I would love, if you guys are convinced that's possible, please send it to me. I'd love to find that exception and share it with everybody, but I've not seen that to be the case. As far as the pharmacy tech piece, I don't really think that saves you much either. That's an act of physically probably handing the med out. What you really need is there's 30 some odd DPC practices in Texas. It's the third largest cohort of any of these states. Bundle yourselves together, hire a pharmacist on your own, and then you get around all this stuff if you actually get one to do things reasonably. But
Okay.
That's the only way I know around this to really dispense it in-house. That's what, Jeff Gold referenced CVS. That's what they're doing, right? They've got a pharmacist and the provider right there.
So, so having a pharmacy tech license is not going to
No.
cut it? No. Okay.
No.
So, all right, thanks.
Last question. I'm sorry. There'll be plenty of time to interact, and we want to get here for our speaker at lunchtime. So last question.
My name is Claire Coco. I'm a family physician in New Braunfels, and I'm going to be transitioning my practice to DPC. I actually sent my patient letters out, and it's all happening in December. And the thing that I've been struggling with is my patient-physician agreement. And so I've kind of patched together information from a variety of different agreements that I found online. It's somewhat cumbersome when the patients go through it. I think it's something that's keeping them from being in my practice some of the times. And so I was wondering if you have any recommendations about the document that you're saying that we need to have our agreement with our patient, if there are any models for us to use, and especially since it's so different state by state, could you make any comments on that?
So I wrote a model contract, put probably close to 1,000 hours of research into that thing because it was an amalgam of several years of looking at this, and handed it out at the DPC Summit last summer. Unfortunately, I didn't have the bandwidth to print those out again. I'm in the process of trying to have that formally published, but I have shared it from time to time. I can try and make that available to you.
And either, Phil, it's available in a very hidden place on our website right now. So if you just contact us, we'll get you. We're happy to go to the website and just request it. Loie Brandon will send a copy of it to you.
Hey, Phil.
I have it typed up as a Word doc. Do you want me to send it to you?
I've still got a copy. Thanks.
Okay.
Okay, well, that was wonderful. Let's have a round of applause for our panelists.